This is a lecture series that brings Colorado law faculty to Denver, a way of extending our reach and engaging more with the community, and not just in your normal reception type settings. Although we do have a reception connected with this, we find that that is useful, conducive to the kind of a discussion we want to have, but engaging in a more substantive way by having one of our faculty talk about their research and the kind of intellectual engagement that they're promoting at the time. And so it's my pleasure to introduce Professor Andrew Schwartz, who is an expert on securities and corporate law. He joined the Colorado Law faculty in 2008 and was promoted to full professor in 2017. Let me just put this aside, and I'll just speak loudly enough. He teaches and publishes, as I said, in corporate securities and also contract law, and has become an internationally recognized expert on securities crowdfunding. Now, securities crowdfunding is not something I knew a lot about until I became familiar with Professor Schwartz's work, and have found it to be quite fascinating, even for someone who is not in the corporate law field. Professor Schwartz was selected as one of our 4 Fulbright research scholars, and he was in New Zealand in 2017 on that Fulbright. And that visit led to multiple articles which drew from his experience with the corporate law community there, including, and it resulted in one article in the prestigious New Zealand Law Review. Other crowdfunding articles or articles on crowdfunding has similarly been published in leading law journals, including the Minnesota Law Review and the Notre Dame Law Review. And I'm sure that those would be of interest to you if all you have to do these days is Google or go to your friendly Westlaw or Lexis, and you can readily find those articles. He's received numerous awards and accolades for his crowdfunding scholarship, among them the University of Colorado Provost's Faculty Achievement Award. And speaking tonight, he'll be speaking tonight on crowdfunding securities. We will have the reception will continue after his talk, and so please stay as indicated earlier. And before I turn it over to Professor Schwartz, I'd like to thank Ackerman for hosting this. As she said, this is the second time that the firm has hosted this. We're very grateful for this partnership, and so thank you very, very much, and for the refreshments that some are already enjoying, but I'll be enjoying, let's say, in a while. So please join me in welcoming to the podium Professor Andrew Schwartz.
Thank you, Jim. Okay, let's see. Testing. So if you can hear me, I'm very pleased to be here. This is a beautiful facility, and thank you to our hosts, and thank you to my dean for giving me this opportunity to share with you some of the background on securities crowdfunding, as well as some of the research that I've been conducting over the past number of years in the field. To give you just an idea about what I'll be speaking about tonight, I'm going to start off with a bit of a background. What is crowdfunding, and then what is securities crowdfunding? I'll explain why we're trying to do this, what the purpose of all this is. I'll tell you about the law, the legal statutes that regulate securities crowdfunding, and I'll give you some of my research and findings that I've published over the past, I guess, 6 years or so in the area. And finally, this is a very auspicious time to be speaking on this subject because the SEC has recently put out a concept release specifically asking for comments on how to reform, among other things, securities crowdfunding. And the deadline is in about 2 weeks, September 24th. It's a very simple online form. If you have any comments, the SEC is, I think, required by law to read them. So that's pretty sweet. So what is crowdfunding? Excuse me. Crowdfunding most basically, or at least originally, was a concept on websites like Kickstarter, where people would contribute money to a certain activity or artistic endeavor, and then receive as a reward for their investment some inducement, often the product itself. For example, if a rock band wanted to record a CD, but it didn't have the $2,000 to rent the recording studio and print some CDs, maybe this is an old-fashioned example, they could go on Kickstarter and request $20 a person and say, pay the money up front, go record the album, and then in return, each person gets the album, however it turns out. One of the features of this type of crowdfunding that I call reward crowdfunding was it generally followed, and still does, an all or nothing model, that the entrepreneur, the artist, would have to say, I need at least $10,000 here. And if only $8,000 is pledged, well, the whole thing is canceled and nobody contributes. And in fact, that's kind of an important protective device for the potential investors, that they wouldn't invest in something that turns out to be so unpopular as to fail to meet the target. But so the idea was, in about almost 10 years ago, to expand reward crowdfunding, which has been tremendously successful. Literally billions of dollars have been raised for projects on Kickstarter alone, and there are other websites that do this. In about 2010, 2012, there was an idea to expand this concept to securities. Instead of getting a CD in return for your investment in the band, you get a share of the profits when they go on tour or sell the CD. This sounds like a great way to promote artists, small businesses, etc., except there's only one problem. It's unlawful. You can't sell securities. You can sell t-shirts. You can't sell securities to the public without first registering those securities with the SEC, which is a complex and costly endeavor. But in order to allow crowdfunding of securities to happen, Congress passed in 2012, with a huge bipartisan majority, the Jobs Act, Jumpstart Our Business Startups, Jobs Act, and part of that authorized equity crowdfunding or securities crowdfunding. And I've sort of hinted at why we did this a little bit, what the purpose was. And really, the primary purpose was to encourage entrepreneurship and promote the economy and encourage startups and jobs that they produce. Hence, it's called the Jobs Act and Jumpstart Our Business Startups Act. Startup companies, as many of you, I think, would agree, are very important to a flourishing economy. They create jobs, advance the economy. And so to allow startup companies and small businesses to raise capital in this crowdfunding manner, Congress passed this new statute and told the SEC to draft regulations. And they gave the SEC 6 months. 4 years later, the SEC published their regulations, and in 2016, securities crowdfunding finally went live. In the interim, other places like Colorado and other jurisdictions, foreign jurisdictions, including New Zealand, said, hey, that idea that you passed in the Jobs Act, that's a pretty good idea. We're going to put it into place, and in fact did years before we finally had our market live. And so, as I think the Dean may have mentioned, I received a Fulbright grant in 2017 to travel to New Zealand and study their equity crowdfunding system, which had been in operation for a few years already by that point, whereas ours was just starting up. And I'll tell you a little bit later in the talk about what I found there and what the differences are in the law. But promoting entrepreneurship generally wasn't the only goal of equity crowdfunding. There really are, there's really two additional goals, and that's to create an inclusive opportunity for entrepreneurs and an inclusive opportunity for investors. And let me explain what I mean. For entrepreneurs in early startup companies, the traditional way to raise the earliest capital for the company is through friends and family, and possibly angel investors or venture capitalists. But what about people who don't have friends and family with money to invest, or live in Iowa, thousands of miles from Silicon Valley? What about people with no connections? People who are out of the loop in one way or another have long had a hard time getting funding for their startups. I mean, just to take one example, female-led companies receive these days maybe about 15% of venture capital funding, and maybe as recently as 10 years ago, that was about 5%. So this crowdfunding, in contrast to venture capital and other traditional forms of early stage capital finance, really was designed to allow all entrepreneurs from anywhere, regardless of who you know or what your demographic background is, to have an opportunity to present your idea to the crowd. And so that was part of the inclusive policy that we were trying to achieve. And then on the other side, so that's for the entrepreneurs. But what about the investors? These angel investors, venture capitalists, are universally accredited investors, or personal friends of the founders. This is because if you sell securities to people who are not accredited investors or personal friends of the founders, you must register them, and that's expensive, and we don't want to do that for the early stage companies at least. So the effect is that for decades now, the opportunity to invest in speculative, risky, early stage companies has been limited to wealthy accredited investors and personal connections of founders. Another goal of crowdfunding was to give all investors from across the country, regardless of their wealth or who they know, an opportunity to, well, as our governor said when he was in Congress at the time, to give an opportunity to everyone, to give an opportunity to ordinary investors to lose money in the same way that millionaires always have. And so there's some concern about that. But the goal of crowdfunding was, so like I'm saying, really, there were several goals. Number one, to create an opportunity for entrepreneurs. Number two, to create an especially inclusive one for entrepreneurs and an inclusive one for retail investors. So now let me tell you just a little bit about the legal framework for securities crowdfunding in the US and compare it to that of New Zealand, because I found it very fruitful in my travel there to learn about how their crowdfunding system works and what the results are and compare it to our own. So like I said, at around the time, so in 2012, we passed the statute, but it wasn't until 2015-16 that the SEC issued the regulations. In the meantime, Colorado, we passed our own crowdfunding statute, Securities Crowdfunding. It's open to anybody. For reasons I'll get into, I think, very shortly, no one has ever used it. No one has ever used the Colorado's crowdfunding statute. However, in New Zealand, there is actually, it's a small country. The whole country is about the same size as Colorado. Actually, within like 3 square kilometers. It's amazing. The population's almost around the same size, very similar size economy. And so it's sort of a relevant comparator to see how their laws work, understanding, of course, it's a different country with different traditions and customs, but having been there, I would say to you, it's like another state, very similar to another state. So in order to protect investors, remember I said then Representative Polis was very concerned, and rightfully so, that retail investors, unsophisticated parties might invest in ventures with no real chance of succeeding, or with run by charlatans who are going to steal the money. Because of these concerns, the United States, in our law, we put significant investor protections in there, including that in the US, investors are only allowed to invest up to, it's like 5% of the lesser of your annual income or net worth in all crowdfunding securities each year. So for most people, let's say it's somebody who makes $100,000 and has $100,000 net worth, they would be able to invest $5,000 in all crowdfunding securities per year as a way to protect them from losing more than they can afford in these unregistered offerings. Unregistered meaning not going through the normal IPO process. In addition, the US exempted crowdfunding securities from the normal disclosures required of a fully public IPO company, but did impose a set of mandatory disclosures, including, in some instances, audited financial statements, discussions of risks, capital structure, related party transactions. This simple, inexpensive method of raising money has regulations that run literally 700 pages. New Zealand took a very different tack. In New Zealand, investors are allowed to invest as much as they want in crowdfunded securities, just like they're allowed to buy as many cars as they want or whatever else they can afford. In addition, New Zealand completely exempted crowdfunding issuers from mandatory disclosure at all. There's no government-imposed form. Unlike in the US, we have a Form C you must file to do crowdfunding. In New Zealand, there's no form, there's no specific required disclosures that must be made. Well, what does New Zealand, how does it work in New Zealand? New Zealand really depends on the platforms, the intermediaries, the Kickstarter-like websites that it's up to the platform hosting any given crowdfunding issuance to tell the company, you must disclose this or this, and this is how we're going to do it. It's up to them. How has it worked so far? This really set up a useful test of, can you have a really deregulated form of public securities offerings? Or do you need all the traditional protections that we have in the US, specifically mandatory disclosure? And well, actually, one other thing I forgot to mention, and I just apologize, is in both the US and in New Zealand, there's a per company cap of about $1 million in US dollars, about $1 million that a company can raise each year. So the company is only allowed to raise $1 million in this fashion, otherwise you must do a normal IPO. But so, like I said, the US in Congress was very worried that fraud would run rampant and investors would lose all their money unless we put in these investor protection measures, which, as we'll see, are very costly and time-consuming and challenging for companies that are early-stage startups with just trying to raise modest amounts of money. Well, just to give you some statistical analysis of what happened, to compare the US and New Zealand is not really fair in a one-to-one relationship. But conveniently, New Zealand has about 1% of the US population and about 1% of the US economy. And so I think it's, you could sort of scale New Zealand up by 100 and say, well, then I'll compare the US and New Zealand. So if we do that scaling, in the first year of crowdfunding, New Zealand had 13 times as many campaigns as the US. New Zealand companies raised 30 times as much money as US companies in the first year of securities crowdfunding. And even, this is now, crowdfunding began in New Zealand in 2014. To date, there have been hundreds of companies funded. Not a single one has been revealed to be a fraud or even accused of being a fraud. I can't say that any of them have provided amazing returns to the investors, but there's, I think, only one company that's actually gone out of business in that time. And so I think, so how does this work? How did New Zealand create which is an orders of magnitude more effective system than our own. As I've mentioned, the costs of raising $300,000 or $200,000 in capital, you can't spend $60,000 in lawyers' fees to do that, or you can't rationally do so. So to raise the small amounts that are allowed in the US, it's so costly that many companies are disinclined to try. There's other reasons as well, maybe why US companies are disinclined. One is, another one that is slightly frustrating, I think, to those of us that support inclusive opportunity, is I've heard numerous advisors say to advisors to venture capitalists, these sorts of folks say things like, and publish things like, well, our firm would never want to invest in a company that had previously done crowdfunding, including because they might have 300 investors or 300 shareholders that the VC fund doesn't want to deal with. This sentiment is widely shared, and whether it's true or not, whether it's a great idea or not, if startup companies are very concerned that this is going to spoil their chances in the future, well, then they're not going to try it. So, but that said, and I did mention that the U.S. had very low numbers relative to New Zealand. I have to say, things are looking up. There's been tremendous growth. 2017 to 2018, for example, 50% more issuers launched crowdfunding campaigns. I don't have our 2019 numbers yet, but it's growing very fast. And whereas New Zealand, I'm not sure exactly what the situation is of late, but I think it's been relatively flat. I don't think it's grown so much. So it's possible that we will catch up. But so then how could it be that people are not losing their money hand over fist in New Zealand without mandatory disclosure and intense government oversight? The structure of the market there has allowed the private actors to, I'm not going to say work out a system, but develop techniques that I'm describing them more than they are thinking that this is what they're doing precisely. But the two techniques that are so effective in New Zealand are the two most important, I call gatekeepers and syndication. So the first one, the platforms, as I mentioned earlier, the platforms that host these companies, they have an intense economic motive to vet the companies that they allow on their site. If there are multiple crowdfunding platforms, if one of them gets a reputation as a place where fraudulent companies list, well, investors are going to stop going there. They will go out of business. They know this. So the platforms are very selective about who they list. In fact, maybe overly selective in New Zealand. In New Zealand, the leading crowdfunding platform was quoted in the paper as saying that they reject 98% of companies that request the opportunity to list on the exchange, on the platform. Whereas in the US, companies have many more opportunities to list. So the economic incentive of the platforms is to police carefully their platform, and they seem to be doing so. The second concept, which I call syndication, it means different things maybe in different concepts, in different areas, but what I mean is where you have one large investor that does some due diligence and looks into things and is fairly knowledgeable and says, I'm going to plunk a whole bunch of money into this. And then another group of people say, hey, that's a good idea. I'm going to follow along with you as a syndicate. In New Zealand, there is no per person investor cap. So unlike in the US, where literally even Warren Buffett would be only allowed to invest $100,000 a year in all crowdfunding companies, in New Zealand, it's lawful. You may invest $200,000, $400,000, $500,000, and that's what we see. The most successful campaigns and the biggest campaigns there have a cornerstone or lead investor who's usually an angel or some sophisticated party who puts in $200,000 on the first day and sort of kickstarts the whole fundraising process. The retail investors can kind of ride the coattails of such a person. And so it's through those two private ordering methods, the New Zealand market has been kept really pretty clean. In the US, the gatekeeping model is available, although in practice, my research shows that the US crowdfunding portals are much more liberal in allowing companies to give it a go. And there's also more than 24 active platforms in the US, so if this one doesn't take you, that one would. One thing, so now let me move to another component, or a closely related aspect here, comparing New Zealand and the US. New Zealand, unlike the US, had and still has a very tiny venture capital community, very tiny, even if you scale it by 100. Even if you scale it to the size of the US, New Zealand's venture capital community or funding is maybe 10% that of the US. They needed to develop a system that really worked, that actually got capital, hard capital to companies, promising companies who need it, who aren't getting it. In the US, we were really more able to say, oh, we've got multiple goals here. We're trying to create an inclusive system. We're trying to create opportunity for all sorts of folks. And so the US system is, in fact, more inclusive and does give companies more opportunity, even at the cost of maybe not working as well, not as smoothly as in New Zealand. So just to give you I have a paper coming out later this year where a research assistant and I downloaded all of the Form Cs that had been filed from the first day of crowdfunding through 2018 in an Excel spreadsheet, and we were able to analyze how old these companies are, how much revenue they have. And what we found was that, let me see here, these are the companies using crowdfunding are the earliest stage companies. The average age is 2 years old. The median is 1.5 years old for companies using crowdfunding. By years old, we mean the date that the company was incorporated to the date that it launched its crowdfunding offering. There were more issuers that were younger than 1 month old than older than 10 years over the past few years. Companies that use crowdfunding have about 3 employees. 90% of them are unprofitable. 25% have 0 assets. Another 30% have like $1. And in comparison, in New Zealand, the average company is 8 years old, much more established, with thousands of Facebook followers that you can mobilize and get the deal done. They're larger, relatively larger companies. And so both countries are kind of achieving our goals. New Zealand, it really does have these, attractive startups that just don't have sufficient capital and can't mess around with anything else, just has to get, real capital going to these people. And through syndication, for example, it's able to double and triple what any individual angel was going to invest. Whereas in the US, we are really giving untested brand new startups a chance from all over the country. In 2018, 44 states had companies that tried crowdfunding. Excuse me here. Oh, and then finally, on the inclusivity of the US crowdfunding market, we weren't able through our data to analyze every aspect of inclusivity, but like I said, geography, 44 states were represented. And as I mentioned earlier, our most recent figures that I've seen in 2018 or so say that about 15% of companies that receive VC funding are female-led or female-founded. Whereas we were able to look at crowdfunding companies, one of the requirements is that the Form C be signed by a senior member or several senior members of the company, senior officers. And so my research assistant and we went through the names of who signed. And when it was an Andrew and an Adam, we said, okay, that's I guess a male-led company. But we counted a company if it were Andrew and Amy. Many names we couldn't tell. Many names we couldn't tell always whether it was male or female. But if we could find a female name as a signatory, we counted this as a female-led company. And on that basis, we found, I think, a pretty impressive statistic of 28%. 28% of the companies in the first 3 years of crowdfunding are female-led in the sense that a woman signed the Form C. So I'd say that is some of my research that I found thus far. I'm going back, thanks to the Dean and the Goldstein Fellowship, I'm going back to New Zealand in January to renew my research there and see how things are going. But like I said at the outset here, and let me just take the last 5 or 10 minutes here to discuss some ideas for reform. Like I said, it's a very auspicious moment, and trust me, I will be submitting a letter to the SEC explaining some ideas for reforming crowdfunding in a way that I think would advance its goals. And so just to give you a couple of the ideas that I'm still in draft form, I still have 13 days to submit this thing. So some of my ideas that I would really welcome your feedback on, in the Q&A, or I'd also welcome other ideas, and I would encourage you, of course, to submit your own, but I understand that practicing lawyers have other things to do. But so my first idea that I think that I would propose to reform U.S. crowdfunding would be to eliminate the per-person investment cap for accredited investors. I understand that we do want to protect our retail investors, our little guys, from losing money in these illiquid, untested, speculative startups. But by definition, accredited investors can afford to lose some of their investment and perhaps have some sophistication. And if we were to eliminate that cap on accredited investors, that would allow for US crowdfunding platforms to develop this syndication model, where you would have someone who puts in 100,000, 200,000, 500,000, and then retail investors can say, I'm with that guy. So that's my first idea. Second idea would be, and this one I'm a little bit torn about because, well, let me give you the problem. The problem is this. Remember, in Kickstarter and in Securities Crowdfunding, the issuer or the proposer has to announce its target at the outset. Need to raise $10,000. And if it only raises $9,000, all bets are off. Everybody gets their pledge back and nothing closes. But if it reaches $10,000, then it closes. And so, and in securities crowdfunding in particular, I wrote before crowdfunding started, and before you market participants outsmarted me, I wrote that this is going to be a very helpful protection to the small investors using the wisdom of the crowd. If I go online and I think, company A looks great and I pledge to invest, but nobody else does, well, thank you, the crowd. Thank you, the crowd, for pulling me back from the edge of making this foolish investment because it doesn't reach its target. What has been happening, the market practice seems to be, from laying out all these issuers one after another, we see that it's perfectly lawful what they're doing, and I'd say it's on advice from the platforms. They are setting, the market practice seems to be to set the minimum that you want to raise at $10,000 or $25,000, even though you realistically want to raise $400,000, $700,000, $1 million. What's the point of, or by setting such a low target, the companies ensure that they're going to meet it. And so the whole protection of being held back from falling off the ledge is gone. So I'm toying with, and there's big downsides to my proposal, but I'm toying with proposing that the SEC should limit issuers to only ultimately raise, say, 2 times or 4 times their target, forcing them to give some sort of realistic assessment instead of this peppercorn. Okay. But obviously, if somebody thinks they only need 100,000, but the thing catches fire and people want to give them $1 million, it's a downside to my proposal that they would not be able to. So I'm not sure about this. Proposal number 3 for reforming the system would be to raise the per company limit, which is currently $1 million, to say $10 million. In fact, companies are only raising, on average, $200,000, something like that. The median is maybe $150,000. The targets, as I told you, are $25,000 and $10,000, and only a handful of companies have raised even $1 million, which is the cap. So, kind of out in the literature, the conclusion is, well, we don't need to raise the cap because companies are able to raise what they need under the current cap. There's an invisible class of companies out there that need 3 million and 4 million and 5 million. And I'm not an expert in the real world as you are, but from what I've heard from practicing lawyers is for a startup, to get from 1 million to 10 million is a tough gap. Once you're get past this gap, maybe the number is somewhere else, but once you get past that gap, you're able to attract larger investors. And at the smaller end, you're able to get some friends and family or local people, but there's this big chunk out there. And so I hear that there are startups that really could use 4 million and 6 million out there. And so I think I'd like to invite them in. And then finally, and I'll conclude with this, the experience in New Zealand, I think, should give us some confidence that there are other ways to prevent fraud and encourage legitimate businesses, only legitimate businesses, apart from intense government regulation. The costs, it's taking more than 100 hours of work time to produce these Form Cs. And when you're raising such small amounts of money, it's inefficient and an unattractive option. In both New Zealand and the US, there's been no instances of fraud. Admittedly, these things are often latent, and when the economy is good, you might not see it. Still, we have a good number of years of experience under our belt, and so I would encourage the SEC, as my 4th and final recommendation, I think, to slim down the mandatory disclosures on Form C to the absolute minimum required by statute. Admittedly, I advised them of the same thing as they were drafting the regulations, and here we are. But in part due to a change in administration, the current SEC seems very enthusiastic about the idea of including retail investors in these private companies, these unicorns, these startups that are currently only allowed to attract accredited investors. So with that, let me thank you for your time, and I really welcome your questions, your comments, and your ideas. Thank you. So I do believe we have time for questions and answers. Yeah. And so, well, at least questions. Yes, Jeff.
Coming from a position of total ignorance, so thank you.
Yeah.
If I want to invest in a company, do I get the disclosures on some website? And then how is my investment limit enforced?
Thank you. So the question is, where do you physically see these disclosures, and how is the per person investment limit enforced? Where do you physically see the disclosures is on these platforms, these websites, and some of the major ones in the field are WeFunder, Start Engine, Seedrs. There's a number of them out there, and you go to their website and there's PDFs to download. Not empirically, but anecdotally, I will tell you the investor information provided on the New Zealand websites that is not prescribed by any government form is user-friendly. It's simple. There's they use color and bolding and things, whereas we have page after page of boilerplate. So you go to the website, and on the question of how are the per person limits enforced, I think it's really not carefully. I think by rule, the platform has to ask you, Mr. Kelson, how much money have you invested thus far in the last 12 months in other crowdfunding ventures? And if you say 4,800 and your annual income is this, they say, oh, you're out of space, or we're gonna. Now you might write, oh, I've invested $3, and I think they are supposed to rely on you. So it's mostly on the individual. Yes, please.
My question is kind of about the syndication aspect you're talking about. So just sort of multi-layered here, but what is the interplay between Reg D and Reg C? And then if they're having to disclose their balance sheets already, aren't they going to see the accredited investors who may have already invested in this company? And then thirdly, with a lot of these accredited investors, they're investing through special purpose vehicles that have some name that is just 3 letters in LLC after it or something like that. I mean, how do you get around that process to encourage the syndication?
Oh, okay. Yeah, no. So just my first question was.
Interplay between Reg D and Reg C. Can you run around?
Right. Yes. What's that called? The rules over when one offering is going to be considered as part of another. Integration. Thank you. I teach corporations, not securities. Integration. The integration rules are something else that the SEC is looking at. They would like to be able to, and in New Zealand, it's becoming a very common practice for the same website to use its same systems to host a simultaneously accredited only, they call it wholesale, but accredited only investment like a Reg D and crowdfunding at the same time. On the point of, let me just say this, to compare the sorts of, on whether accredited investors are already invested in a company that does crowdfunding, I'd say that almost never happens. Oh yeah, they're so early stage. Only I think about 10% of US crowdfunding companies have significant earlier investors, whereas it's very common, maybe 70% or more in New Zealand. So as a practical matter, it just hasn't come up yet. And was there a third question? Right, the special purpose vehicles. So if the SEC were to adopt my thought.
And then these accredited investors are making their investments, but they're making them through ABC, LLC. You don't know that that's Warren Buffett.
Right, okay, this is a fair point. On syndication, the one large investor gives confidence to the others, and so how would that work if it's just a dummy name that's not known? The investor, if the company and the investor want to publicize the investment, I think they'd be perfectly free to do so. And so I think they would structure it that way if what they want to do is make a splash with a known name. I think it's also maybe rational for retail investors to adopt a strategy of anytime somebody's invested more than $300,000 in a company, I'm going to do it too. I'm going in. Just on the assumption that someone with that amount of money and willing to put it in. Now you could see there might be an opportunity for malfeasance, maybe especially if my proposal to raise the limit up to $10 million is adopted, which makes it more worthwhile to take the risks. Please.
So this question is kind of informed by our kind of size we operate at. We deal with a lot of entrepreneurs who will come to our office and they've just binge watched Shark Tank and they say, I'm going to raise this much money on this much of a valuation and it's going to be great. And we realize, wow, we need to have an instant crash course on how startup fundraising works. You are not doing it correctly. We need to stop. And that serves as a useful check because if they would have gone and crowdfunded, they would have raised maybe $1 million, however much they would have gotten, not enough money to retire to Aruba, and not enough money to cause real economic damage to the investors that they're doing. If we raise this point to $10 million, and now it is either enough money to embezzle and retire forever, or truly create significant harm before they ever have to go engage counsel who will get them to the next step, do you propose another mechanism to create almost a diligence check on the investors? Because I think the difference between a person who's been Shark Tank raising $1 million, reaching the end of their funds and not having a mature company and not having retirement money is very different from someone raising $10 million and either bringing a company to fruition to then fail or then retiring for the rest of their life. Do you find that the system will need another backstop if we raise the limits to, like, say, $10 million?
Yeah, so the question is, if we were to raise the limit to, say, $10 million, would we want additional protections or backstops for the investors? I think maybe what we have is a situation where the current system is appropriate for such an amount. I think that's the best that I could say. I mean, audited financial statements is a pretty heavy burden, and so I think that maybe my answer to your question, or it's not a fair one, is we've already got it right. We just need to switch the amount. But this is a very fair concern. Please.
So kind of dovetailing off the side of like a lot of people that we see. I mean, in the startup world, I mean, a lot of the times these guys aren't even looking to raise 500,000. So what is your thoughts on even potentially expanding it to even further reduce the cost of the disclosures you have to make when you're trying to raise between like 50 and 250,000? Because I mean, for some of those guys, paying an attorney $5,000 is undoable. So.
Yeah, no, I agree with you. The question is, what about those raising, really relatively small amounts, 100,000, 200,000? Conceivably, we could. I guess maybe what we've got here in our current system is it's a little betwixt and between. It's inappropriate for both, maybe, but maybe with some slight reforms to the regulations, we could get something that's appropriate. The goal is for that to work. And in New Zealand, the costs are so low that I think most people do it, most companies do it really with the aid of the platform as kind of the expert, as more than an attorney there.
Has there been discussion of a tier system where if you're only looking to raise sub $1 million, there's a sort of tier of disclosures and diligence, and then if you want to be one of those $10 million crowdfunders, the gatekeepers will take a more substantive role in vetting your company? Have you, in your experience, encountered those discussions? Yeah,
the question is, have there been discussions of tier disclosures within crowdfunding? And I don't have it right in front of me, but I do think that the original statute required audited financial statements for all companies, but the SEC put in a regulation saying those raising under 500,000 are exempt from audited financial statements. So there's definitely already an idea that we're trying to achieve this. At the same time, the whole goal of this is to create a simple system that's really user-friendly. And if we make it with so many tiers and so much, we might make it overly complex.
Okay.
Well, thank you again.
Thank you. Thanks a lot.
Thanks, Phil.
Well, thank you. Thank you, Andrew, for a terrific talk and discussion. So that ends this evening's presentation. We can continue to more drinks and some food, I believe. There's another Colorado Law Talks coming up I want to let you know about on November 6th. Professor Suzette Malveaux will be presenting on national injunctions, judges gone wild, or just doing their job. And it will be hosted at Polsinelli, so hopefully we'll see you there. Thanks for coming, and enjoy the reception.